Hello, this is Professor James Strickler. This is a course in American government. This lesson is from Unit 12 about the Georgia Constitution. It's Lesson 5 about Georgia government structure. In this lesson, you learn about state popular sovereignty, about state separation of powers, and about state judicial review. Remember that we're now going through the Georgia Constitution. We began last lesson to talk about the Bill of Rights, which is Article 1 of the Georgia Constitution. The things we're going to be talking about today are also included in Article 1, even though there's things that you might not immediately think of as being part of a Bill of Rights. A way to understand why they might be put in a section about Bill of Rights can be understood if we remember this thing that we learned in a previous lesson. A right and a power are essentially the same thing. They're just two sides of the same coin. If you as an individual possess control of this thing, we call it a right. If the government, on the other hand, possesses control of this thing, we call it a power. So talking about what powers a state might have is in a way the same as talking about what rights people might have. Because if you say the state has power over a certain thing, then you're implicitly saying people don't have a right for that thing. If you talk about people having right for a thing, then you're implicitly saying that the state doesn't have power over it. So even in a Bill of Rights, it's a reasonable thing to talk about the structure and powers of the government. So Article 1 of the Georgia Constitution, in addition to listing people's individual rights, also talks about the origin, purpose, and structure of the power of the state government. Here's one of the things that it says there in Article 1 of the Georgia Constitution. It says that the government originates with the people, and it's founded by them. It then goes on in the next passage to say that the people have, after having created this government, have a right to alter it or reform it anytime they want. Now, this is a very important concept, that the people control the government, not the other way around. This is the great American experiment. This idea that Americans way back at the founding inherited from things like the Magna Carta and the English Bill of Rights, that they then embodied in the Declaration of Independence and the United States Constitution, which begins with we, the words we the people. It's this incredibly American notion that the people are in charge of the government, not the other way around, and that there's certain things the government isn't going to be allowed to do to the people. Well, we've described that concept previously in this course as what we call popular sovereignty. Remember, sovereignty means ultimate political control. There's no one above you to tell you what to do. Popular sovereignty means that it's the people who are sovereign. So there's no one above them to tell them what to do, but they are above the government to tell it what to do. This is a fundamental notion about the founding of the state of Georgia, contained in the Georgia Bill of Rights. The Georgia Bill of Rights then goes on to talk about how the powers of government will be distributed. It talks about that there will be a legislative, a judicial, and an executive branch, and that their powers will remain forever separate. This is a concept that previously in the course we've talked about as separation of powers when we discussed it in the national government. Remember, we talked about how that there are three branches of government: the legislative branch, which makes the laws, the executive branch that carries out the laws, and the judicial branch, which decides whether or not we've obeyed the laws. We then talked about how these roles are fulfilled in the national government by the Congress being the legislative branch, the President leading the executive branch, and the Supreme Court being the head of the judicial branch. Well, these same sort of divisions exist within the government of the state of Georgia. There's a legislative branch, an executive branch, and a judicial branch. Here in the state of Georgia, the legislative branch goes by the name of the General Assembly. We'll talk more about the General Assembly in a later lesson in this unit. The leader of the executive branch in the state of Georgia is the governor, very similar to the president at the national level. We'll talk more about the governor in a later lesson too. The courts in the state of Georgia have at their top a Supreme Court. Same name, same sort of function as the Supreme Court of the United States. Now, in creating these separate powers, even though it doesn't explicitly talk about it in this part of the Georgia Constitution, there's an implicit idea in the way these governments are set up. And that is that their powers will overlap in some ways, allowing them to then potentially check and balance each other. You may recall when we talked about these checks and balances for the national government, we talked about things like the president being able to veto a law. Well, when we talked about those things with the national government, one of the things that we understood was that those checks and balances weren't all as explicitly listed in the Constitution as they should have been. In particular, the Supreme Court at the national level wasn't explicitly given a way to check the other branches of government in the Constitution. The way that they ended up seizing a power to check the other branches is through a concept called judicial review. Judicial review is the power of the courts to look at some action by somebody else in government and decide whether or not it is okay under the Constitution. And if it's not, then the Supreme Court can declare their action, whatever it is, to be invalid. But when we talked about the national government and this concept of judicial review being the way that the Supreme Court in that national government could check the power of the other branches, we also learned that the Constitution doesn't say anywhere that they can do this. They just simply did it, like in the case of Marbury versus Madison, which we discussed in detail earlier in the course. They did it, they exercised judicial review, and then they got away with it. Well, the courts don't have to do that in the state of Georgia, because in the Georgia Constitution, it explicitly says that any acts of the legislature that violate the Constitution of the state of Georgia or the Constitution of the United States are void, and the judiciary shall so declare them. This is the power of judicial review, being mentioned explicitly in the Georgia Constitution. But it doesn't just say that the courts can exercise judicial review. It gives them a constitutional responsibility to do so. They're in Article 1 of the Georgia Constitution. It's part of the Georgia Bill of Rights that the courts of the state of Georgia must exercise judicial review to strike down unconstitutional acts. Let's review now what we learned in this lesson. Who is the ultimate power in Georgia government? Is it the governor? Is it the General Assembly? Is it the Georgia Supreme Court? Or is it the people of the state of Georgia? The ultimate power in the state of Georgia is the people. It's this idea of popular sovereignty that we learned previously in the course. It is embraced in the founding document of the state of Georgia. Actually, I shouldn't even call it the founding document now, should I, since it's been replaced 10 times. Maybe I should say the governing document of the state of Georgia. What is the required relationship between the three branches of government according to that state constitution? Is it that the legislature is supreme to the other branches? Is it that the branches must cooperate with each other? Or is it that the branches must be separated from each other? Or is it that the Supreme Court decides what their relationship is? According to the Constitution, the three branches of government must be separate from each other. So where does Georgia get this idea of judicial review from? Where do the Georgia courts get it? Do they get it from Article 1 of the state constitution? Do they get it from the case of Marbury versus Madison? Do they get it from Article 3 of the United States Constitution? Or do they get it from some state Supreme Court decision? The courts in the state of Georgia get the idea they can exercise judicial review because Article 1 of the state constitution, the state Bill of Rights, specifically says that they can exercise judicial review, even gives them a responsibility to do it. All right, that completes this lesson. The next lesson will also be from Unit 12. It'll be Lesson 6 about Georgia elections.